Thank you, Dr. Whittle, for having invited me to be a part of this prestigious event. The topic I thought was appropriate for delivering this talk today was the recent notification of the Consumer Protection Act. Many people have discussed with me this and have raised questions. So I will be speaking predominantly on recent amendments in CPA and its implications for doctors, which is a question which was asked to me recently by a very senior doctor. Now, this is something which has to be very, very clearly understood. There are no recent amendments in Consumer Protection Act and its implications. This has to be understood very, very clearly. There are no recent amendments in CPA. There is a Consumer Protection Act 1986, which has been repealed totally, and a new Consumer Protection Act has been passed by the Lok Sabha on 30th July 2019 and was passed by the Rajya Sabha on 6th August 2019. And this has now been notified via Gazette notification dated 15 July 2020, and the new act is applicable from 20th July 2020. Most of the sections of the new act have been notified and are valid in the country today. Some exceptions are there. Why is this topic important? The WhatsApps and the emails were flooded with the celebratory messages from doctors in doctors' groups that doctors are removed from the ambit of Consumer Protection Act. Now, this was probably because in 2018, when the draft bill was framed, in the section which gave the definition of service, the word healthcare had been included. Indian Medical Association and others had represented to the government, and there was a lot of pressure created on the government, and the government decided to drop the word healthcare from the list of services which were given in the definition. Mr. Ramvilas Paswan, in his speech in the Rajya Sabha, made certain categoric statements that healthcare will not be covered under CPA. There is a literal interpretation of section 2, subsection 42 of CPA 2019, where a list of services has been given in which healthcare is not specified. And true to our nature, all doctors want to be out of Consumer Protection Act, and there is a rationalization of this personal belief, which is why everybody assumed that healthcare has been removed from CPA. And there is a very selective reading of the law. But what is the actual law which has been passed? The section 1 subsection 4 clearly states, save as otherwise expressly provided by central government by notification, this act shall apply to all goods and services. Where has the government in this act or by any notification removed healthcare? The government has not done that. And since it has not done that, all goods and all services are covered. Look at the section 2 subsection 42. This is where healthcare was dropped. What does this say? That service means service of any description which is made available to potential users and includes, but is not limited to the following examples. So these examples are simply illustrative. They are not comprehensive. And this is something which has created the confusion in the mind of doctors, plus, of course, the political propaganda and the political juggling which went on to pacify doctors at that time to pass the Consumer Protection Bill. The section 4 of the Consumer Protection Mediation Rules 2020. Now, there are certain rules also which have been framed, and this relates mainly to which cases can be referred for mediation and arbitration. And it says very clearly that the matters relating to proceedings in respect of medical negligence resulting in grievous injury or death cannot be referred for mediation. What this indirectly means is that medical negligence and doctors are covered under the purview of Consumer Protection Act, though an act should be used to define rules and regulations. An act should be used to interpret rules and regulations. Here, the rules are being used to clarify something in the act which does not carry as much weightage. And please remember, the Consumer Protection Act of 1986 had only 31 sections, and despite all the amendments which came up to around 42, 48 subsections, the CPA 2019 has 107 sections. It is a much more elaborate and much more difficult act where doctors are concerned. The section 34 says district commission shall have jurisdiction to entertain complaints where value of goods or services paid as consideration do not exceed ₹1 crore. A lot of talk has gone along that the pecuniary jurisdiction of compensation has changed. What has been done here is the compensation asked for has been removed when jurisdiction is being decided. Here, the issue is any case where a consumer has paid less than 1 crore. These cases will be heard in district commission. Nowhere is it mentioned that the person would have asked for compensation of less than 200 crores. Nowhere is it mentioned that the compensation asked should be less than 1 CR. It simply says that the value of goods and services which the consumer has paid should not exceed 1 CR. And there is another very troublesome and a very worrying section which has come in here, which says that now a complainant can file a complaint not only where cause of action occurs, but also where the complainant resides or personally works for gain. This is a very, very serious matter. Patients from all over the country, they flock to certain metropolitan cities because of better healthcare facilities. Now a person in a remote district in Bihar, in Assam, in Kerala, in Tamil Nadu, now under this act will have a right to get treated in Apollo Hospitals, Delhi, but go back and file a case in the district commission from where he belongs. And the doctor will have to fight his and defend his case in the parent district of the complainant. This is something which is going to create a lot of problems for doctors, though it is justified by the government agencies that by saying that this act has also brought in the concept of video conferencing into the Consumer Protection Act. So a person who's defending or a person who's filing a complaint doesn't physically need to be there in the court. That may be said as it may be, but practically, I feel that this is going to create much problems for doctors. Another issue in the act, it has been overlooked that the qualification of the president of district commission, which was mentioned and specified very clearly in the 1986 Act, this has been omitted in the 2019 Act. Though while passing the rules, in 2020, they have put in the definition, but again, the rules are here defining the Act, which is something which is appropriating too much powers in the hands of the executive, which is actually a legislative function. The Qualification of the president of district commission, state commission should have been mentioned in the act itself, because it was a legislative domain and not a domain of the executive to decide who can be the president of district or state commissions. The 1986 Act favored or pampered the litigant in consumer courts. But the 2019 Act, if doctors are included in this, doctors should shudder to enter the hallowed precincts of consumer courts. Their lives are going to be miserable. Their hands, feet, head, body, entire thing will be shaking when they are operating. This act is going to create a major upheaval in the way healthcare is practiced in our country. This is something which is taken in defense by the government agencies, that e-filing of complaints, this and video conferencing which is being introduced. But please remember, when you say e-filing of complaints, it means it is going to be much more easier for somebody sitting at home, somebody disgruntled, to file a complaint like he is posting a Facebook message. This contains enabling provisions for consumers to file complaints electronically and for hearing and examining through video conferencing. Appeal can be filed now only after depositing 50% of the compensation awarded. Earlier, it was 50% or 25,000 rupees, whichever is less for district to state commission, 35,000 rupees or 50% of the compensation awarded, whichever is less, from going from state to national commission, and 50,000 rupees or 50% if you wish to appeal a national commission decision. Now, there is no 25,000, 35,000, 50,000. It is straight 50% of whatever compensation has been awarded. Mediation as alternate dispute redressal mechanism has been introduced in CPA 2019. This I consider as a welcome step. Complaint will be referred by the consumer commissions for mediation wherever scope of settlement exists and parties agree for it. Mediation cells will be established under consumer commissions, and there will be no appeal against the settlement through mediation. Medical negligence resulting in grievous injury or death cannot be referred for mediation. A lot of doctors try to settle their cases by entering into a out-of-court settlement. This is something which should be stopped. Let us do the settlement. If a person does want to go for settlement, that settlement should be court supervised, and this mediation and arbitration is a good mechanism, because after this settlement, the patient party does not have a right to go in appeal later. There is something called product liability provision, which has been added to deter providers from providing deficient services. It allows person to make a claim of product liability against a manufacturer or a service provider for any defective product or deficiency in service. A claim for compensation may be made for any harm caused, including personal injury, illness, or death. So this product liability provision is something now which is going to come more and more into the litigation for medical negligence. E-commerce has also been included, but then this also means that probably the video consults, Practo, and other platforms will need to be scrutinized more carefully when signing agreements with them by doctors. Compared to the previous act, the following have been added to the definition of unfair trade practice. Unfair trade practice was there in the CPA 1986 also. But the product liability clause which has come in now, I feel this is going to place the manufacturers of surgical goods, the manufacturers of accessories, the manufacturers of medicines at loggerheads with doctors, because there are a number of scenarios where the doctors are caught in a medical litigation because of a defective product. And at times, doctors use the products as a common practice against what the product information says. I'll give you some examples. Avastin as an injection is used by ophthalmologists right, left, and center for diabetic retinopathy. Roche has clearly stated in court that Avastin is not meant for ophthalmic use. This kind of conflict between the manufacturer and the doctors, because the manufacturer is the one who will be held more liable and probably have to shell out increasing compensations as evidenced from what has happened in the West. So they will defend themselves and we will be at conflict with the manufacturer of drugs and disposables and machinery equipment. There are instances where during surgery, pottery burns have occurred on a patient's or a child's body. These are all issues which will create more problems for doctors in courts. In unfair trade practices, failure to issue a bill or a receipt has been added as an unfair trade practice. Refusal to accept a good returned within 30 days is also accepted. I don't know how this is going to affect doctors. A lot of doctors dispense medicines, and if a patient comes to return those medicines within 30 days, will this clause apply? I mean, I may be worrying too much, but if we go exactly by law, this could create a problem. And disclosure of personal information given in confidence unless required by law or in public interest. We have now today so many authorities on us, whether it is PCP, NDT, Clinical Establishment Act, Consumer Protection Act, and besides the police and the judiciary and the civil surgeons and the health authorities, where we are by law expected to provide information regarding our patients. Soon, someday, a conflict will arise where personal information of patient which is shared with the authorities or whom we consider authorities may create a problem for us. Another thing which has come in new is the Central Consumer Protection Authority. This was not there in the 1986 bill, and this Central Consumer Protection Authority will have its own Chief Commissioner, Director General, Investigative Wing, and complete office staff and complete investigative staff, whereby a complaint made to this authority will investigate the matter on its own and if needed file a case with consumer courts or give appropriate directions for appropriate actions. So this could be in addition to a case being filed in the consumer commissions. This CCPA is a new regulator. This has been established by Section 10, subsection 1 of CPA 2019 with an aim and object to promote, protect, and enforce the rights of consumers regarding misleading advertisements and unfair trade practices. This is where I am most concerned that doctors now will be targeted under unfair trade practices in Central Consumer Protection Authority. It will have the power to inquire or investigate violation of consumer rights or unfair trade practices suo motu, or on a complaint received or on a direction from central government. The CCPA shall also have an investigation wing which shall be headed by Director General appointed by the central government. This authority shall protect, promote, enforce, prevent unfair trade practices, ensure that no false misleading advertisements, ensure no person takes part in publication of any advertisements which is false or misleading, This may cause an inquiry or investigation, file complaints before district state commissions, intervene in any proceeding before district state commission, recommend adoption of best international practices on consumer rights and to ensure enforcement of consumer rights. This is the area where I feel doctors will be affected most. And issue safety notices to alert consumers against dangerous or hazardous or unsafe goods and practices. Instead of a cap on compensation, with Indian Medical Association and doctors have been asking from the government, there is now expected to be an increase in number of cases filed for compensation due to ease of filing. There is e-filing and video conferencing. District commission filing will be there for 99.99% cases. There is going to be a deemed admissibility of complaint after 21 days of filing. A patient files a complaint, the consumer court does not take a decision regarding admissibility. After 21 days, it is deemed to have been admitted. The person can sue a doctor from his sitting at his hometown, and there is no fee that he has to pay when he files a consumer court case for services paid up to 5 lakhs. Again, please remember, not where the consumer is asking for a compensation of 5 lakhs. It is if the consumer has paid up to 5 lakhs for services, he does not need to pay anything as court fee to the consumer courts if he is filing a complaint. Again, 99.9% of cases against doctors will fall in this category. So what it effectively means, that cases filed against doctors for medical negligence, the patient does not have to pay a single penny if he wants to file a complaint in the consumer court, which is different from what it used to be in CPA 1986. There also the fee was nominal, but at least it was there and it acted as a deterrent. We also expect exorbitant compensations being awarded, because by increasing the pecuniary jurisdiction of consumer commissions, the Act de facto accepts that compensations up to and above 10 crores can and should be asked for and awarded. The VP Shanta and others versus Indian Medical Association had shown very clearly that before this judgment and after this judgment, there was a substantial and exponential increase in number of cases filed against doctors for medical negligence. Now, any manufacturer or service provider who causes or false misleading advertisement to be made, he shall have imprisonment for a term which may extend to 2 years, with fine which may extend to 10 lakhs, and subsequent offense, the prison term may extend to 5 years and with a fine of 50 lakhs. This part has been kept in abeyance. It has not yet been notified, but I'll come to this point later. A product service provider shall be liable for a product liability action if there are act of omission or commission or negligent, conscious withholding any information which could cause harm. The service provider did not issue adequate instructions or warnings to prevent any harm, and this is likely to increase cost of medical equipment, pharmaceuticals, resulting in an increased cost of treatment, increased compensation claims, increased indemnity insurance costs, and consent. Consent will become a major problem here. There is also a concept of unfair contract, which has been brought up in CPA 2019. A contract is said to be unfair if it causes significant change in rights of the consumer, and it will be declared null and void. It includes requiring excessive security deposits, imposing disproportionate penalty for breach of contract, refusing to accept early repayment of debts, terminating the contract without reasonable cause, transferring a contract to a third party, imposing unreasonable charge or obligations which put the consumer at a disadvantage. As per section 49 subsection 2 and section 59 subsection 2, the State National Commission respectively shall have power to declare any terms of contract which is unfair to any consumer to be null and void in the eyes of law. Now please remember, when you take a consent, it is a contract between a doctor and the patient. The only place in Indian law where a consent has been defined is in Indian Contract Act. And this can be declared now null and void if the terms of contract are held to be unfair to the consumer. Earlier, on the basis of facts, you went from one commission to one forum to state commission to national commission in appeal. Now the second appeal to National Consumer Dispute Redressal Commission, as per section 51, subsection 3 of CPA 2019, a party shall have a right to file second appeal in NCDRC only if the subject matter involved in a dispute possesses substantial question of law. If it is simply a question of facts, it cannot be taken to National Consumer Dispute Redressal Commission, and it will go to simply to State Commission, and unless and until you can show that a substantial question of law is involved, then and only then will National Consumer Dispute Redressal Commission come into the play. No other service provider has as many number of cases filed against them as are filed against doctors. Compensation of crores awarded against them. In fact, advocates are not covered under Consumer Protection Act as of now. There is also a new power which has been given to district, state and national commission, which is a power of self-review. The commissions can on their own review their own order, or if within 30 days of passing the order, one of the parties makes an appeal to the same court, to the same commission, they can review their own order. This was not there earlier, at least not with the district and state commissions. These are the sections which have not been yet notified, and this includes establishment and functioning of the CCPA, which I mentioned earlier, e-selling and sale of goods and provisions of services, punishment for false and misleading advertisements. These are all the sections which have been excluded from notification, maybe for some reason, maybe partly because the CCPA requires an elaborate structure to be established before it can become functional. So the question which is asked to me is, what is the solution for doctors? We have shown very clearly that as per this act, as per the law as we understand it today, doctors are included under Consumer Protection Act. We also know very clearly that 1995 VP Shanta and others versus Indian Medical Association, this judgment, once it came in, it has not been appealed against for the past 25 years. Now, there is no way we can go in appeal against this three-judge judgment under which all of us have been suffering for the past 25 years. So what is the way forward for medical organizations, for medical associations? What we are suggesting is all new cases of medical negligence which are filed in consumer courts, each doctor should take a preliminary objection claiming that doctors are not covered within the ambit of Consumer Protection Act 2019. The briefing of the Lok Sabha, Rajya Sabha made by Shri Ram Vilas Paswan are a matter of record. This can be accessed on the net through Rajya Sabha, through Lok Sabha Secretariat, and we should simply claim that doctors, to the best of our knowledge, are not covered by CPA 2019, because VP Shanta and others had interpreted CPA 1986. Now, that CPA 1986 has been declared null and void. CPA 2019 is a new act, and there is no such interpretation given by Supreme Court regarding CPA 2019. So we should forget VP Shanta and others. We should start taking preliminary objections, stating very clearly, putting in news clippings that doctors are no longer included within the ambit of Consumer Protection Act, and let the district forum say, no, this is wrong and doctors are included. We will keep going in appeal till we again approach the Supreme Court with a bunch of cases and their Indian Medical Association, Medical Legal Action Group, all groups should be prepared fully to plead in this case when it reaches the Supreme Court, so that a proper representation can be made and doctors can have a chance of getting themselves excluded from the purview of the Consumer Protection Act 2019. There are many arguments which can be used there, but the simple solution is start de novo, start new cases. In the new cases which are filed after July 20th, simply take preliminary objection, say very clearly that to our understanding CPA 2019 does not cover doctors. Let the court come up with the other arguments. We give our arguments, let us lose, let us keep going in appeal till this matter reaches Supreme Court, and there use the full force and the full might, including all the finances we can raise, to fight this case once again. It is an opportunity in front of us, and if we still don't use this opportunity, we have no right to crib. Thank you so very much.